Second, is the unequal treatment lawful so that no contravention of sections 4B, 4C, and 4D, or any of them in relation to a police officer? Your Lordships, as with any constitutional issue or motion, standing is the vehicle which brings us to the courthouse steps. Without standing, any of the issues mentioned previously would be worthless and irrelevant. I will therefore address standing first in regard to both claimants respectively. Whether the claimants are able to seek constitutional redress in the High Court of Arawak, specifically their rights as per the Constitution. Within the Constitution itself, there is a clause addressing the ability of a claimant to seek redress when he or she feels that rights provided for within such Constitution have been violated. I quote from Section 14, Parts 1 through 5 of such Constitution, which reads as follows. For the removal of doubts, it is hereby declared that if any person alleges that any of the provisions of this chapter has been, is being, or is likely to be contravened in relation to him, then without prejudice to any other action with respect to the same matter which is lawfully available, that person may apply to the High Court for redress by way of originating motion. Section 14 therefore allows both claimants the ability to seek a challenge to the violation of their constitutional rights and fundamental freedoms. They are claiming that their rights have been contravened, as stated in Part 1 of Section 14, and as stated in Part 2b. They are pursuing a constitutional question in regards to the rights stated in subsection 4 that were being violated. They are therefore permitted under the Constitution to seek a constitutional motion in the High Court.